attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the final segment in a Lawcast series discussing SEC disclosure requirements, and in particular, the 341-page Regulation SK concept release and request for public comment issued by the SEC on April 15, 2016. Risk-related disclosures need a thorough review and potential overhaul. Although the SEC has long stated that risk factors should not be boilerplate repetition of items applicable to the market as a whole and not necessarily applicable to a particular company, most companies use boilerplate language. I note that item 503 contains 5 examples of risks that a company can make related to its offerings. And so, of course, those risks in boilerplate format are always included in registration statements and reports. These 5 risks include a lack of operating history, lack of profitable operations in recent periods, financial position, the business or proposed business of the company, and a lack of a market for the company's stock. The instructions to item 503 require companies to refrain from presenting risks that could apply to any company, but they do so anyway. The SEC continues to push for particular material risk factors and not boilerplate industry risks. For example, a risk that refers to the general state of the economy and that a company's business would be adversely affected by a change in the economy would apply to every business and does not offer particular material, meaningful disclosure to investors. Likewise, a risk that a company faces competition and may not compete successfully is entirely generic. The SEC has gone so far as to suggest placing a limit on the number of allowable risk factors to force companies to provide meaningful risk information. Currently, risk-related disclosures are included in multiple items under Regulation SK, including item 503 related to investment risk and item 305 related to market risk. The SEC is also considering aggregating risk information in a more central, readable format and improving the content to enhance investors' ability to evaluate the particular risk factors. As part of the presentation, the SEC suggests that risks should be presented in order of importance, with the most significant risks first, and again, only the most significant or principal risks included at all. The SEC also seeks comment on whether requiring a company to explain the probability of a risk and steps taken to avoid a risk would assist in requiring companies to be more specific and precise in explaining their particular risks. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.